stop whatever you're doing, because what you're about to hear could redefine justice in India forever. The entire foundation of India's legal system has just been shaken. A secret draft was dropped that almost changed who controls every lawyer, every courtroom, and even the Bar Council itself. I'm talking about the Advocate Amendment Bill 2025, a proposal so controversial, it united the entire legal fraternity in protest. Lawyers poured into the streets. Bar councils called emergency meetings. For the first time in years, India's legal community said enough is enough. Before we dive in, take a second to hit subscribe, like this video, and share it right now. Because what's happening here isn't just a lawyer's story, it's about your rights, your justice, and your democracy. Let's make sure every Indian hears what's being planned behind closed doors. But what exactly was in this bill? Why did lawyers call it a threat to democracy itself? And why did the government suddenly pull it back after nationwide outrage? Let's break it down step by step, so you understand why this law could have changed India forever. The first shocker was that the bill gave the central government the power to nominate 3 members to the Bar Council of India. It might sound small, just 3 members out of many, but here's why it terrified everyone. The BCI isn't just another committee, it's the regulator of all lawyers in India. It decides who can practice, sets ethical standards, disciplines misconduct, and safeguards the autonomy of the legal profession. For decades, the BCI has been independent, free from political control. But under this bill, it would no longer be an autonomous body, it would become an arm of the state. Once the government gets the power to choose members, influence begins who the council disciplines, which lawyers are favored, which cases get attention. This isn't a small administrative tweak, it's control over the very gatekeepers of justice. Critics called it a direct attack on judicial freedom, and they were right. If the regulator becomes political, the profession loses its shield, and citizens lose their voice in court. The second controversy was about foreign law firms and how they operate in India. In 2012, the Supreme Court's A.K. Balaji judgment clearly said that foreign law firms can advise on international law but must remain under BCI regulation. This bill flipped that ruling. It handed control over to the government, allowing it to decide which foreign firms could enter India and how they'd operate. That means global firms with billion-dollar budgets could enter the Indian market overnight. Imagine corporate giants from London or New York competing directly with small Indian law firms. The fear was simple. Indian lawyers would be wiped out by global competition. For young advocates, this was devastating. They spend years preparing for practice in a system that ensures fairness. Now, the same system was inviting foreign players who didn't even have to pass Indian exams or follow local ethical codes. The BCI had spent decades building strict professional standards. By stripping away its authority, this bill risked opening the floodgates to unregulated competition. What looked like reform to some was, in truth, a quiet takeover of India's legal industry. Then came the most dangerous part, Section 49(b). This clause allowed the government to issue binding directions to the BCI. That means a body created to regulate the legal profession independently would now have to obey government orders. That's like telling the Supreme Court what judgment to pass. It kills the principle of independence. So far, if you like the video, don't forget to subscribe to KanoonPlus and hype this video in support of struggle for autonomy of lawyers community. Legal experts said this section was unconstitutional. It centralized control, suppressed dissent, and turned the Bar Council into a puppet. And it wasn't just theory. Imagine a future where a lawyer criticizing the government could be silenced because the BCI received instructions to act against them. That's how fragile independence can become when politics enters regulation. But the government's influence didn't stop there. Another clause allowed it to decide enrollment fees, the money new lawyers pay to join the profession. That might sound technical, but here's the problem. When the government controls the cost of entry, it controls who gets in. Make it too high, and thousands of students from poor backgrounds are locked out. Make it too low, and the market floods with untrained entrants. Either way, the result is the same control. The legal fraternity saw this as a financial chokehold on independence. Bar councils at both national and state levels said this is our domain, not the government's, because whoever controls the finances controls the future. Then came Section 24(b), the Disqualification Clause. It said that any lawyer convicted of an offense carrying a sentence of 3 years or more would be disqualified from practicing law. Now, no one supports unethical lawyers, but 3 years is too low a bar. The BCI objected immediately, saying it should be raised to 7 years, restricted only to serious crimes. Because what happens when a lawyer takes up a politically sensitive case and a minor complaint is filed? That lawyer could be convicted on flimsy grounds and instantly banned. The concern wasn't just fairness, it was survival. This clause could be used to target outspoken advocates, especially those defending citizens against powerful entities. By keeping the limit so low, the bill created a backdoor weapon, a way to silence inconvenient voices in the courtroom. As if that wasn't enough, the bill also criminalized lawyers' strikes and boycotts, treating them as contempt of court. Yes, protesting could now land a lawyer in jail. The BCI was furious. It argued that the right to protest is fundamental not just for citizens, but for those defending citizens. Throughout history, strikes have been the legal community's last resort against injustice. By criminalizing them, the government wasn't just silencing protests, it was choking dissent itself. Experts called it a blow to democracy's spine. Because if those who speak for justice are gagged, who will speak for the people? Beyond these 5 big issues, the bill had more hidden dangers. It authorized the central government to form oversight committees for state bar councils, effectively bringing them under political watch. It even redefined the term legal practitioner, opening the door for unregistered or unqualified individuals to act like lawyers. That's right, people, without proper credentials, could technically represent others in legal matters. The BCI called it the death of professionalism. And the final insult? The bill ignored every single recommendation made for lawyers' welfare: no pension, no insurance, no protection. Advocates who faced threats, violence, and financial instability were left out completely. For a bill claiming to reform the legal system, it forgot the very people who keep it alive. As outrage grew, lawyers began to unite like never before. Courts slowed down, protests spread, and the message was loud: we will not let our profession be controlled. Within weeks, the pressure reached Delhi. Bar councils met the law minister. Senior advocates wrote open letters. Even retired judges voiced alarm. And finally, the government blinked. The Union Law Ministry withdrew the Advocate Amendment Bill 2025 after nationwide protests. It announced that it would rework the proposal after fresh consultations. So as of now, the bill is not in force. It's on hold. And that happened because the legal community stood together. But the story doesn't end there. The Bar Council of India has since doubled down on its authority. It's issued strict warnings to Indian and foreign firms not to operate as joint entities. Under the new BCI rules, foreign lawyers can only work in India in very limited case-specific circumstances. In fact, one of the biggest cases, the Denton's Link legal case, is still under review in the Delhi High Court. For now, the BCI continues to hold the power, but the tug of war between autonomy and control isn't over. This isn't just a legal story anymore. It's a test of how much independence a democracy can actually tolerate. So what now? Here's the roadmap that could protect the future of India's legal profession. Remove government nominees from the BCI and restore full autonomy. Keep the regulation of foreign lawyers strictly under BCI oversight. Raise the disqualification threshold to 7 years to protect fairness and due process. Safeguard the right to protest. No law should ever criminalize dissent. And finally, implement welfare and security measures that protect the people who protect justice. This saga teaches us one powerful truth: eternal vigilance is the price of liberty. The moment citizens stop paying attention, control quietly replaces freedom. The Advocate Amendment Bill 2025 may be withdrawn, but its shadow still hangs over the legal system. Will reform return as collaboration or as control? That depends on you. Because the law doesn't protect people, people protect the law. If you believe in an independent judiciary, share this video now. Comment your thoughts, hype the debate, and make your voice count. And if you haven't yet, subscribe to KanoonPlus for more deep legal insights and support the lawyers community for their autonomy and freedom. Stay informed, stay aware, and never stop asking who really controls justice in India. Jai Hind.
Friends, don't forget to share your views in the comment box and subscribe to KanoonPlus channel.